Well, hello, everyone. My name is Cynthia Olmedo, and I'm the Assistant Director of Alumni Career Services. Welcome to Employment Agreements to Sign or Not to Sign workshop. Students are presented with employment contracts, including non-disclosure, non-compete, and non-solicitation agreements. So the purpose of this presentation is to assist with navigating these agreements and to better prepare you to read and understand some of the terminology and implications. There will be a brief question and answer session after the presentation. So today, I would like to introduce our presenters from our very own Entrepreneurship and Community Development Clinic at the University of Houston Law Center. We have Professor Christopher Hurd, Nathaniel Green, and Michael Crump. Welcome.
Thanks for the introduction. My name is Nate, and I'm here with Mike, and we're students at the Entrepreneurship and Community Development Clinic. Just to give you a quick background about the clinic. It's a legal clinic, so there are law students who help small businesses, nonprofits, other small companies, typically in the Houston area. We help them with forming their company, drafting documents, agreements, basically any transactional or kind of the paperwork side of law. So we don't do any lawsuits, but we help businesses with some of their paperwork legal needs. Professor Hurd is also here with us. He is the director and supervising attorney of the clinic. So he's the person that signs off on all the work we do. But we're not here to talk about the clinic. We're here to talk about non-disclosure agreements and non-compete agreements and give you some education on that. So just as a disclaimer, there are a lot of rules behind what constitutes legal advice. So to be clear, this presentation is just for educational purposes. It's not legal advice. Mike and I are students, so we're not allowed to give legal advice. Professor Hurd is a licensed attorney, but anything that he says say also is not legal advice. And no one listening to the presentation is a client of the clinic. And this presentation also is not us trying to tell you this is when you sign, this is when you don't sign, rather just give you kind of general education about these types of agreements and what considerations to think about when you have one in front of you and you are reviewing it. And lastly, this presentation is focused on the laws of Texas. Different states have different laws and rules behind what can be in a non-compete and what can be in a non-disclosure. So we're just going to focus on Texas. So next slide. This is just a brief agenda of what we're going to talk about. First, we're going to go over just contracts generally, just so that we're all on the same page about what the contract is, provide some definitions and examples of contracts, and then also talk about what makes contracts enforceable. And then we'll get into kind of the main part of the presentation, talking about non-compete agreements and non-disclosure agreements, provide definitions, talk about enforceability and the laws and consequences behind these types of agreements, discuss why employers want you to sign one, and what to think about when potentially negotiating these types of agreements, and we'll also provide some example language of these agreements. And the last bit of the hour and a half will be dedicated to questions you might have. So if you have questions as we're going through the presentation, jot them down and then please ask them at the question period at the end. Contracts in general. Contract is an agreement between two parties that they intend to enforce against each other, and they're governed by certain laws. Now, all contracts need 4 components. They need an offer, acceptance, consideration, and mutuality. Now, an offer can be a simple oral offer, right? Someone saying they will pay someone to do something, or it could be a very long document, but there needs to be some sort of offer that one party offers to another party. So the example on the slide for the offer is Mary saying she will pay, or Mary saying, I will paint your house for $100. That's her offering to do a service for $100. Now there needs to be an acceptance of the offer. Typically how the offer is stated tells you how you need to accept the offer. In this case, it can just be a simple oral acceptance of the offer. So Tim can say, I accept your offer and will pay you $100. And by saying that, Tim accepted the offer, even though he didn't necessarily sign anything, he still accepted that offer that Mary proposed. Now, contracts also need consideration, and this is the thing of value being exchanged. The thing of value could be money, could be an item, a product, a service, a promise, basically anything that's valuable can be consideration. So in the example with Mary and Tim, Tim's consideration, the thing of value he's bringing is the $100. And the thing of value that Mary is bringing, her consideration, is the promise to paint the house. And there needs to be an exchange of those things in order for the contract to be valid. Now, contracts also need mutuality. That means that both parties need to understand and intend to be in the contract. So let's say that Mary understood that she would paint Tim's house in Houston, but Tim understood that Mary would paint his house in Austin. There could be a lack of mutuality there because they don't understand, and they're not understanding the exchange of consideration is the same. So in that case, there could be lack of mutuality. So that's kind of before needed things for contracts. So we go to the next slide and discuss the enforceability. Obviously, what I just said, the contract must contain all 4 elements. And one thing to note is if there's new consideration, if there's a new thing of value being proposed, there must also be new consideration for the other party. So say Mary offered to paint Tim's shed, she would need to receive something of value in return for painting his shed. She would need to receive return consideration for that new agreement to be valid. Now, another important thing to note is just because you have a document in front of you that you are signing does not necessarily mean that that document is an enforceable contract. Even though it says, contract at the top and you sign at the bottom, it's not necessarily enforceable if it's lacking any of those components, or if it doesn't comply with relevant law. So courts do not enforce contracts that are contrary to state or federal law. And that's one of the things that we're going to be kind of focused on in this presentation in terms of what is the law behind non-compete agreements and non-disclosure agreements. So that's contracts very briefly, but now we'll kind of dive into non-competes, and I'll hand it over to Mike.
All right, so the first part we're going to go over is a non-compete agreement, and you might see them referred to in different ways. Sometimes it's called a non-compete. Sometimes the contract might say that it's called a covenant not to compete, or it could be just listed as a restrictive covenant in the agreement. So it goes by a few different names, and basically what it is, it's an agreement between the employer and the employee to limit the employee from competing with the employer for a certain amount of time. And that competition doesn't necessarily have to be just working for another competitor. It could also be like starting up another business. So if you go and you are working for a company and you want to start a competing business, that might be against a non-compete agreement. The laws that govern non-competes vary from state to state. So in Texas, it's governed by sections 15.5 to 15.52 of the Texas Business and Commerce Code, but that's different in every state. So if you are going to be working in another state or getting an employment offer from another state, it's kind of important to look at what the state's requirements are, because so while our presentation is going to focus on Texas, it could be different depending on where you are. So the first thing we're going to kind of go over is what makes a non-compete enforceable. And so there's a test that the court used, and this is outlined in the Texas statute, that gives them kind of like a framework for what a non-compete actually needs to have to be an enforceable agreement. So in addition to what Nate talked about in terms of it being enforceable as a contract as a whole, it has to have these elements to it. So a non-compete agreement must be ancillary to or part of an otherwise enforceable contract. It must be reasonable on restricting the employee in terms of the time, the geographical area, and the scope of activity. And lastly, it has to impose no greater restraint than necessary to protect the employer's business. So over the next few slides, we'll kind of dive in a little bit to what those actually mean. And the first part is the non-compete must be ancillary to or a part of the otherwise enforceable contract. And basically what this means is there must be other parts of the agreement that go beyond just the non-compete, and that the agreement as a whole has to meet the requirements for general enforceability that Nate mentioned earlier. So the example you're most likely to see, being recent graduates or soon to be graduates, is it's an employment agreement. You're usually given, you might be given one at the outset of your employment, and but the non-compete could also be outlined in, excuse me, it can also be valid for current employees, but then the employer has to give new consideration, like Nate mentioned earlier. So for them to enforce a non-compete agreement or have it be part of an otherwise enforceable agreement, you have to have received something in return. So at the outset of your employment, that could be your initial employment with the company. But if you're already working for the company, they'd have to be giving you something new to add this new restriction on you. So one example of that is the court upheld a non-compete agreement where the person involved signed it, but it involved stock options. So where they were exercising the options, the employee could not compete with the company for 3 years. So once they made that exercise, the non-compete was enforced, and the court determined that that was an enforceable contract. So the next step is restricting the employee, and it has to be a reasonable restriction. And so the three things that they outlined were time, geographical area, and the scope of activity. So what those basically mean is, when it comes to time, that's the length of the term of the restriction. So it depends on the facts. A lot of what I'm about to say is going to be kind of fact specific. So it's you'll see that it's kind of a range. But so courts have generally upheld in Texas a duration of 2 to 5 years, but it does depend on the circumstances. When it comes to the geographical area, courts have upheld employees' former territories, or if you're involved in like sales and have a specific region, that region that you're involved in is probably going to be a reasonable restriction. They've also upheld instances where it was the entire area of the employer's operations. So if the company, for example, only worked in Texas, maybe that Texas region is enforceable. But this isn't exactly a hard and fast rule. You'll notice the employer basically just has to show that they have a legitimate business interest in protecting that restricted area. And another thing to note is that it's not strictly geographical. So what I mean by that is it doesn't necessarily have to be like an area on a map. It can also be like a series of customers that maybe the employee was, working with. Sales is kind of the easy example. So if you're a salesperson and you have a customer list that you're working with for that company, they might be able to restrict you from using those customers if you were to go to another organization. So that's also been upheld by the court, and it's not strictly a geographic region. One example that was upheld is that, so there was an employee that worked for a company that had territory that expanded across the United States and Canada, which seems like a really, really large geographical area, but the employment agreement restricted the non-compete to only 20 competitors, not every competitor that they have. So the court upheld that as being reasonable because it narrowed it down strictly to the competitors that the employee was directly working with. But an example that would be too broad for the geographical area was one that included all areas of operation. So for the company, it expressly included all of their worldwide clients, and not just the ones that the employee specifically spoke to or worked with. And so the court determined that that was too broad. It was basically preventing him from working for effectively anyone in that industry. Oops, sorry about that. And the last portion, the scope of activity, and basically that means what activity is being prohibited by the non-compete agreement. And generally it has to be limited to activities of the employees, but it also can be like using a specific training or a skill that was provided as part of the employment, or working in an activity that involves the trade secrets or confidential information that the employee may have worked with. And generally, like I said earlier, an industry-wide prohibition wouldn't usually be enforceable, but if they limit it to the specific customers and tie it to what the employee did, it may be. Or if it's related specifically to trade secrets, then it may be considered enforceable. So like I said, it's a bit of a fluid test, but these are the kind of the things that the court's going to look at. So the last part of the test was that is the non-compete must impose no greater restraint than necessary on the employee. And so what this means is the employer basically has to have a valid reason to require the employee not to compete with them. So an example would be for keeping business interests. The employer invests time and money and training into an individual. So, or if the employee is exposed to confidential information or trade secrets, and the employer would want to protect them or protect that training that they've invested in that employee and prevent it from going to another customer. So like the training example, we want to incentivize the employer to provide training for their employees, but they also don't want the employee like to invest thousands of dollars in training them and then have them leave immediately and go work for another company. So that might be a reason that they would want to restrain the employee. Secondly, there's a factor of maintaining goodwill, and why does it keep doing that? The non-compete agreement basically the employer would want to maintain the goodwill between the employee and its customers. So business, you'll see as a lot relationship building. And so the employer wants to foster relationships with customers between its employees and those customers. But they might be less willing to do so if they know that that employee could then take those relationships, move to another customer or another competitor, start their own business, and basically take that business with them. So that would be a protectable interest for the employer in maintaining the goodwill of the employees between their customers. So here's an example of a non-compete provision within a contract, and I'm gonna ask you guys to take a moment to read through it, and Nate's gonna pop up a vote because nobody wants to hear me actually read this. So take a look through it and see if you think that it has all of the elements that we just talked about. Staying pretty steady. We've got basically 2/3 of our group thinks that the agreement is valid, and about 1/3 of the group thinks the agreement is invalid. So let's walk through this real quick, and we'll kind of clear things up with you. So first, I'll start by saying that this agreement likely would be considered valid. To kind of walk through the test a little bit with you guys, you notice these highlighted parts kind of key you in on it, and the first two highlighted sections are going to deal with the time frame. And so this one is limited to during the employee's employment, and then 2 years following the termination. So as we said earlier, generally the courts are going to uphold an agreement that's, you know, in that 2 to 5 year range. If it's less than 2 years, obviously that's even less restrictive. So that would works to their benefit. And then the next section is it's going to go over the prohibited activities. So they can't set up, join, become employed by, engaged, all of this kind of stuff, this laundry list. And you'll notice when you guys get these kind of agreements, this is a key section to pay attention to, because this is, you know, kind of outlining, you know, what can you or can you not do. So that's kind of getting to where the scope of the agreement is. And then, so while this agreement doesn't have a geographic region to it, you'll notice that it has, it's tying it to what the employee actually was involved in. So it says the employee obtained or new confidential proprietary information during the last 2 years. That's what they're trying to limit, but it's with who they were with business of the company with which the employee was actively involved in. So it's tailoring it, instead of it being a geographic region like being Texas or the United States, it's limiting it to that customer list. And while it's not specifically stating that it's customer A, B, C, or D, that's probably going to be enforceable because it's limiting to who the employee was actually tied to while they were employed with the company. So for that reason, it's likely that this is going to be considered an enforceable agreement. So one other thing that we wanted to touch on, because it's kind of something you'll see hand in hand with a non-compete agreement, is an anti-solicitation provision. And so what that is, it's a provision that is to prohibit the employees from attempting to hire the employees, the employer's other employees, sorry, and or to create contractual relationships with their clients, customers, or business partners. So basically, if you get taken, if you're an employee of the company and you go to another organization, they might not want you to reach out to your coworkers and take them with you, or reach back out to the customers that you had or the clients of that business and take them with you to the other organization. So that's kind of where anti-solicitation comes in. And they're definitely a different provision from a non-compete. They're totally separate, but the courts look at them with the exact same tests, and they are governed under the exact same sections of the code in Texas, which is 15.5 and 1552. But again, like we said earlier, if you're working in another state, definitely make sure that you check and make sure that the requirements could be different. It applies the same way. They might have different anti-solicitation requirements in California, for example, that would make an agreement enforceable or not. So it's something to be aware of. And just for another fun reading exercise for everybody, here's another example for you guys to take a look at. And we have another poll if you want to take a stab at seeing whether you think this is an anti-solicitation provision, and we'll see if you think this one is enforceable or not. All right, so yep, basically it stayed the same. We had 2/3 think the agreement is valid and 1/3 thinks the agreement is invalid. So we didn't go through and highlight the provisions of this one, but I will say that this one is also likely to be a valid agreement. It kind of covers the same thing in terms of its time, and the scope of the agreement is kind of within what the courts would find to be valid. And then one thing to also call out again, you'll notice that there's probably no reasonable geographic area listed from a map perspective. But again, just the same with as with the non-competes for non-solicitations without geographic limitations regarding a customer, where they've narrowly tailored it to the employee, for example, the customers that they're specifically working with, the coworkers in their department, that kind of thing. It's been considered reasonable and has been upheld by the courts. But just to kind of call out, it's important to read these things through. I know a lot of the times you get inundated with paperwork when you're hired or if you're going through an internship, and these kind of documents can be really long, but it's very important to kind of just take a quick look through them, read through, check for those tests, because it kind of gives you an idea of whether or not what they're asking for is actually reasonable or not, and it gives you a little bit of leverage. So one thing we wanted to kind of talk about is what happens if you're offered a job after you've signed a non-compete agreement, and it may be in violation of that non-compete agreement if you take that job. So like this is basically how the process of a dispute would kind of play out for you. The first part is there's likely to be some internal worry on your end because you might be worried about taking the job and whether that actually is going to have a negative impact by breaching the agreement, whether it's actually going to be a breach of the agreement. So there's definitely going to be a little worry on your part. The next step is when your current or former employer becomes aware that you are going to be breaching the agreement. Likely what's going to happen is they're going to send a very strongly worded letter and threaten legal action to kind of scare you into compliance. The reason is this is the cheapest way to kind of address the problem, and they're hoping that by pointing out in a very strongly worded manner that you're in violation of the agreement and that there could be consequences, that you'll just comply with it, which is definitely something to think about. And it would depend kind of on the situation. But after that, let's say you continue and you take that position, the employer has the option then effectively to pursue legal action against you, and they may or may not do so. So even though they have an agreement and you may have breached it, it's up in the air. Now, I'm not saying that means you're free and clear and you're more than welcome to breach all agreements because they'll never come after you, but it is up in the air. And the reason is litigation is expensive. Going to court is expensive. Attorneys are expensive, which works very well for Nate and I sometimes. We hope so in the future at least. But going through that whole legal process is expensive for an employer. And it would be expensive on your end as well if you're having to defend yourself. But from the employer's standpoint, they're going to basically do an internal cost benefit analysis, and they're going to determine whether or not they think it's worth it to protect whatever it is that they thought they were protecting in the first place. They're going to look at the agreement and determine whether they think it's enforceable. They'll look at the agreement and determine whether or not effectively what you were doing or who you were in contact with is worth them going through the trouble of trying to obtain a legal a result in their favor. So not making any promises one way or the other, but that's kind of what the process would end up being. So let's say they do take you to court. What happens if they determine that the court looks at it and thinks it's an unenforceable non-compete agreement? So that doesn't necessarily mean that it's immediately invalid. And that's something kind of, very important to be aware of. Just because the agreement is invalid doesn't mean it's immediately just unenforceable altogether. They'll throw everything out and you're free and clear. So the court has the ability, and they do this very frequently, to reform the agreement that is considered overbroad but otherwise enforceable. So what that means is if they think that on the whole the agreement is fine, but there's maybe one provision that is overextending, like for example, the geographic area, if the court determines that the geographic area in the agreement is far too broad and say they made it so that you can't work anywhere in the United States and that's far too much, but the intent of the agreement was that you guys would have some sort of limitation, that's the only part that's overbroad. What they'll do is they'll effectively write in what would have been a broad, or not broad, sorry, would have been a reasonable geographic region. So maybe they'll limit it down to Texas, and then they'll determine whether or not there's actually been a breach of the agreement. So that is definitely something to be aware of. If it looks like it's unenforceable, don't bank on that. There are some instances though, that if the employer knew that the non-compete agreement when at the outset was unenforceable, but they still try to enforce it, the employee may be entitled to recover the costs spent during litigation, just something to be aware of. So kind of lastly, let's say the court determines that you are in violation of the agreement, what can happen next basically? So they've got really three options, I guess. There's damages, injunctive relief, or a combination of both. And basically damages are your financial penalties. So the employee might be required to pay amounts of the profits the employer lost from the employee moving to a competitor. It's difficult to kind of pin those kind of values. And they'll determine that in the court proceedings, kind of to put a number on the damage, which can get very expensive very quickly. And then the other option is injunctive relief. And what injunctive relief means is basically just, it's a court order requiring the employee to stop competing. Anytime you see the words injunction, it's basically they want to stop you from doing something or prevent that action. And so the court could say that you basically shouldn't be competing. You shouldn't open that other business. It's in violation of the agreement. You have to stop. So those are kind of, they can do a combination of the two of them. It could be injunctive relief and a damage penalty as well. So that's kind of wrapping up what would happen in the event that you had a non-compete and you decided to take another job and kind of violated it, and those were the process that you go through. So next, we'll go into a non-disclosure agreement.
Yeah, so non-disclosure agreements are basically an agreement, and this is in the employee-employer context, but it's an agreement that the employee will not disclose information that the employee got while working for the employer. So there's a lot of different information that could be, which we'll go into in a little bit, but basically it's the employee agreeing that they're not going to disclose confidential information of the employer. Now there are different names for these that you might see. The non-disclosure might be called a confidentiality agreement, but they're all kind of the same thing. And as an employee, you might see NDAs just while working. If you are doing consulting work, you might have it sign a non-disclosure with that other party. You might have a non-disclosure when you're doing research and development. There are different times when you'll sign a non-disclosure, but we're going to be kind of focused on employee-employer non-disclosures. And these agreements may be either an agreement themselves, so the only document or the only agreement in that document is the non-disclosure, or it could be incorporated into a larger agreement, such as an employee agreement, where you have everything listed out that you're agreeing to as an employee, and the non-disclosure might be in that agreement. Next slide. So what's usually covered? Typically, I think when people think of non-disclosure agreements, you're agreeing not to disclose whatever research you're working on. If you're in research and development, or if you're in business development, you're not going to disclose who your clients are. But really, there can be a lot more in a non-disclosure agreement. It can be kind of any information that the employer doesn't want to be public. It could be personal information of employees of that business. Another example is trade secrets, which range from a number of things from very valuable information down to just how a company conducts business. So what's covered is very broad and really depends on what's in the agreement. So that's why it is very important that when you are looking over a non-disclosure, you really understand what you aren't allowed to disclose to anyone, so that you make sure that you don't do that once you sign it, if you sign it. Next slide. So enforceability is a little bit different for non-disclosures than for non-competes. Non-disclosures aren't covered under that Texas business code that Mike mentioned. So there is a different standard. There's no explicit requirement that it be part of an otherwise enforceable contract, etc. And another thing to note is that, like I mentioned, there might be a large employee agreement that has both a non-compete agreement in it and a non-disclosure agreement within the broad employee agreement. And if there are reasons why the non-compete is unenforceable, that doesn't necessarily render the non-disclosure unenforceable. So you definitely, even though you think non-compete's invalid, the non-disclosure might still be valid. And courts typically look more favorably at a non-disclosure than a non-compete. And part of the reason for that is non-competes restrict employees, and Texas doesn't like restricting employees. They like people being able to work freely in the marketplace, for a more efficient marketplace. But courts also like making sure that the information companies develop stays with that company, because they expend those resources. They want to maintain those resources. So in that sense, NDAs typically are more enforceable or will be more enforced than a non-compete. A non-disclosure is a contract. So again, you still need to get consideration. So if this is something you're signing at the beginning of your employment, that the employer giving you employment is the consideration that you're receiving for the non-disclosure. But if you are asked to sign this right as you're on your way out and you're not getting another salary, or you're not getting anything in exchange for signing this non-disclosure, then potentially you're not receiving consideration and it might not be enforceable against you. The duration of a non-disclosure is also not subject to the reasonable time period that was required with the non-compete, and these can be much longer in length, but how long they do go depends on what the agreement says. Typically, confidential agreements survive termination of employment, especially if you're given like a trade secret, something that's confidential that the company really wants to keep secret. You're going to make sure you don't disclose that well past when you leave the company. So yeah, trade secrets generally have long terms. One example of a trade secret is the recipe for Coca-Cola. I think that's kind of the standard example. But that's been a trade secret for however long Coca-Cola has been around. And presumably there are people that have known that and have been under an NDA that cannot continue to say that even if they've left Coca-Cola. But it is important to note that this is all present in the agreement itself. So we'll need to look at what the agreement says. Next slide. Consequences for violating an NDA are similar to the consequences of violating a non-compete. You could have an injunction, which is where a court orders you to stop disclosing the information that you disclosed, or you could have damages in the terms of the amount that you gained from disclosing that information, or the amount your former employer lost when you disclose that information. And like Mike mentioned, it's the same kind of process where you might get a letter saying, stop disclosing this, that's their cheap route, but then they might go in and actually sue you. And a company might be more motivated to sue you if you disclose the recipe for Coca-Cola than if you were, an intern or entry-level employee moving companies. That's not as harmful to that company, whereas if you disclose a really, really valuable information. So reaching a non-disclosure agreement might make the company more motivated to go after you. So that's definitely something to consider as you're looking at this, what you can and cannot disclose. One thing I want to mention also, it's might be somewhat rare, but because you took company information and gave it to someone else, that's arguably stealing that information, and there are certain laws behind that that can make you criminally liable. You could someone could go after you for crimes of stealing information. So that might not be super common, but it is something to be aware of, that if you take that information and give it to someone else, that could be considered stealing. Next slide. So why do employers require you to sign an NDA? They've taken resources and put those resources into developing information, and they want to keep that within the company. So they'll make you sign an agreement that you're not going to bring those resources elsewhere, right? So they are preventing you from bringing resources outside the company, and they don't want those resources competing with them. It also prevents them, just in general, makes employees feel more comfortable in certain instances. If you have an NDA saying you're not going to release any personal information, that might not be harmful to the company monetarily if you release that information, but it might harm their reputation. So that's another reason that companies make you sign this. Next slide. So I just wanted to walk through a couple of clauses in NDAs. I'm not going to read them, but just kind of give you an example of what you might see in a non-disclosure. So at the beginning of a non-disclosure, if it's a standalone agreement, you'll have these introductory clauses, which include preamble, recitals, etc. And these just kind of define who the agreement is between, the employee and the employer, and also just expressly says that there is an exchange of consideration, just to make it more clear that it's enforceable. Next slide. NDAs will often define the confidential information that's being protected. So this is, when you're reading these, this is what you read to see, okay, this is the information that I can not disclose. So this is something obviously you look at before you sign the agreement, but it's also probably something that might be useful to look at throughout your employment, just to make sure you understand, oh, I'm working on this project as part of my NDA, and I need to make sure that I'm keeping this confidential while I'm working on this. And it can include lots of different things, business processes, trade secrets, etc. And typically in this section, they also expressly say that the employer is going to be very harmed if you disclose this information, and they're not going to be able to recover from that. So it's a way to signal to the court that this is important information. Next slide. So another clause is the disclosure and use restrictions. So this is basically what you are agreeing to. So you can see at the top it says employee agrees and covenants, and then what you're promising to do. So you're promising to treat everything as confidential. You're promising you're not going to disclose it, make it public, give it to anyone that doesn't need to know, etc. So this is what, if a employer sues you, this is what they'll look at and say, this employee agreed not to directly disclose this information, and they did that, so they breached the contract. Next slide. Here are permitted disclosures. So this doesn't necessarily need to be in the contract because there are laws behind this, but basically a non-disclosure can't prevent you from disclosing information that you are legally required to disclose. So if you're subpoenaed for whatever reason, or you're ordered to come into court and talk about something that might be covered under an NDA, you might have to disclose that regardless. And that goes back to the kind of the beginning of the presentation, where courts do not enforce agreements that go against state law. So if there's a law saying you have to disclose this, that NDA goes against that law. And there are there's various language for this. It might be a court order. It could be, I see in the second one, something they have to do for the SEC or some other regulatory agency. But that's just to make you aware that just because you signed an NDA doesn't mean you can never ever disclose that in any circumstance. There are certain circumstances where you might be required to disclose the information. But if someone comes to you and says you have to disclose this, that might be a good time to seek legal advice as to whether or not you should. So next slide. There's going to be a duration clause in the non-disclosure. It tells you how long you have to keep things secret. This is something definitely to look at, so you understand, especially as you're leaving the company, how long you have to maintain confidentiality. Oftentimes it's however long that thing is secret, that's how long you have to keep it secret. So the recipe for Coca-Cola, as long as it's secret, you have to keep it secret. But if for whatever reason that recipe got out, now everyone knows it, you probably aren't going to be required to maintain that secrecy. Sometimes, and you see in the last sentence, it says continue no longer than 2 years. Companies don't necessarily need to put that in there. Some might, but that's just something to be aware of, that clause isn't always in there. Next slide. So this is a security clause, and this is another part of what you are agreeing to do. So in this clause, you're agreeing that you will use whatever security policies are used by the company to make sure that that information is kept secret. Right? You're going to lock everything up. You're going to use passwords. You're going to only use certain access codes, that sort of thing, when you are dealing with confidential information. That's just another thing to be aware of, is what processes you need to do in order to keep that information secret. Next slide. Lastly is the exit obligations. So this is what you're agreeing once you do leave the company, how you are going to make sure that you aren't going to disclose that information once you leave. So oftentimes, it says you'll have to return everything. You can't keep anything. You have to shred anything that might be confidential, that you don't need anymore, that sort of thing. So this is something to be aware of and look at when you're leaving the company in terms of what you need to do. Next slide. Yeah, so these are potential considerations. I'll hand it back to Mike.
Yep. So one thing to look at is, does it matter when you sign? This is kind of just a recap of what we said. And, for the non-compete to be valid, remember that you have to have received consideration, which means you have to be receiving something of value. And generally speaking, like we said earlier, if it's at the onset of employment, you're receiving that job. You're basically, the consideration being exchanged is you're agreeing to work for them, they're agreeing to pay you. And so then this can be tied to that. But if they're trying to give you a non-compete after you've already started working there, it may be tied to a bonus. It could be tied to a raise. It could be tied to a promotion. There's a few other things, but they have to be giving you something in return. Kind of to the same vein of that, an NDA signed at the end of the internship or employment where you're no longer paid after signing may be unenforceable. Same for the non-compete agreement, just because there's that lack of consideration. So just something to be aware of. More often than not, you're going to see these things, especially at the outside of your career, when you start the job. As far as why would you sign one? Well, you're probably going to be required to sign it to get the job or internship, unfortunately. It's kind of, there may be some negotiating leverage that you have, and I'll talk about that in a second, but the big reason for it is you're restricting yourself to effectively get the job that you're after. But as far as best practices, when you're given or looking at a non-compete or an NDA, the first thing, read everything. Make sure you read through the agreement. Look at, all of the clauses that we kind of called out. Look at the tests that we have given, because that kind of gives you an idea of the important pieces to look at and whether or not it's going to be enforceable or not. And it's just have an understanding for what you're agreeing to. And that's just advice with any agreement that you ever see. I know legal documents get really long and really wordy, and you think that attorneys are paid by the word, but it's one of those things where it's really important to read it, because that's what you're agreeing to do, and there are consequences if you don't do so. As far as understanding your negotiating leverage, have an idea when you're going into this. If you want to negotiate the agreement that's being put out in front of you, is it a job or an internship where you've got multiple offers lined up and the employer is competing for you? Or is this an instance where, to be honest, you're lucky to even have an offer and you really, really need to take it? Don't get me wrong, that doesn't mean you have to, you're desperate for a job, you have to sign everything that's put in front of you, but it's going to come into play when you're kind of debating how much leverage you actually have, because there are definitely circumstances where in a hot job market or in a highly competitive internship, they're coming for you. So just understand that you do have some leverage in that situation. And then in understanding what negotiation would accomplish, ask questions about the agreement, specifically in an internship situation. We talked a lot about, kind of the requirements and how it's supposed to be protecting the employer, but in an internship, especially in one where you may not have a job afterwards, or there's no promise of employment afterwards, maybe ask them questions about, why they're asking for a non-compete agreement, and then kind of you can point out that the purpose of an internship is training as a student. You're learning the job, and that you're trying to keep your options open after graduation. And the point of you entering into this internship is to make yourself more employable after you've graduated. That might be a little different if in a formal job situation, because you've already, they're not necessarily doing it for your training or for your further employability, but it is something still to look at. And to that same vein, like the confidentiality provisions might make sense, whether it's an internship or an employment situation, just because you could be exposed to confidential information. And like Nate said, courts usually look at those more favorably. And so there might be a little less room to negotiate when it comes to that. But just kind of make sure, like we said, read everything, get an idea of where you kind of stand, and you can ask the employer questions when you're going through that process. And more often than not, they should be happy to kind of explain why they're doing something. And lastly, piece of advice: keep everything that you sign, keep a copy of it. I know going through the hiring process can be a bit of a whirlwind sometimes with having you sign a whole bunch of documents, but if you've read through everything and done, checked all the boxes, signed all the paperwork for them, if they don't give you a copy, make sure you ask for one. It won't be a problem. But it's very important that you keep everything that you've signed and hold on to that just in case. Like more often than not, you're not going to have a problem, but you want to make sure that you're covered and that you've got copies of everything that you've agreed to do. And then also, if there's those situations like we talked about earlier where you have another employment opportunity, this gives you the opportunity to look back at what you've already agreed to, and you can kind of look through that and see what make the right decisions for you. So that wraps up our presentation. Thank you guys for listening to us. And hopefully that was helpful. We'll open it up to questions. Just a kind of reminder from the disclaimer that we are law students, not actually licensed attorneys. So this is not legal advice. We can answer general questions, not anything that's kind of a specific situation. And the presentation is not intended to provide specific advice on anything. We can't answer like when I should sign or if I should sign, but just kind of the general questions that you may have. And also, one last point, we've said this about 4 times, this is only going to really be applicable to Texas. Like I said, if you're going outside of Texas for your employment, you're going to need to check with the state-specific laws in that area.
Thank you for the presentation, guys. I appreciate you guys giving this presentation. I have like a general question about, I don't know if you guys studied this or not, but Intel was founded by previous employees of IBM. So did like non-compete agreements not exist back then, or how were they able to do that? I don't know if you read up about that or not.
So I know I remember that I knew that they were involved together. We definitely don't think we had a case like that in law school, like that specific instance. But I mean, just because there is a non-compete doesn't mean they'll always enforce it, like I said. So that's definitely could have been part of the equation. I don't know the specifics of that fact or like what exactly happened there, but you know, it's kind of one of those general. It might not have been worth their while to enforce it. It might have been unenforceable in that instance. They might not have used any protected information or something along those lines. It might have been past the time. There's a bunch of different reasons. I'm not sure of the specific ones, but it could have been a variety of things. I think non-competes have been around for a long time.
Oh, okay.
One thing, just someone asked in the chat if the slides are going to be available. I posted a PDF of the slides in the chat. Does anyone else have a question?
Can this be shared? Can this be shared on email? I'm unable to download anything.
I don't see why not.
Sure,
Cynthia,
can
I
share
think if
it.
you can send it out to the group, we can make sure you get a copy of the PDF if you can't download it.
I'll put my email in the chat, and then if you would like the presentation, I can email it to you.
So,
I have a
Thank you.
question.
Oh, sorry. I was wondering with the non-compete agreements, it was saying if an employee went to a different company or whatever, they're not supposed to talk to their previous other employees. So what about people who had like relationships or friendships or things like that? Like what if somebody were be getting married or something and they quit the job and then they came over? So how would that be something that you'd see?
Yeah, so the answer to everything law school related is always it depends. But so when they're talking about limiting it, and Nate, you can chime in if you also want to. It's like, are you asking if you're just talking to them in general, or if it's just somebody that you're friends with that happens to work at the company that has quit and wants to come work where you're working?
Well, kind of both, because I know kind of both those situations, but for me, I was mainly thinking of if like it was just people that you talked to at the company itself that you were, I guess, became friends with, and then are you supposed to?
So there's no issue like just communicating with anybody, as far as I'm aware. Like if you're not talking about anything relating to like trying to get them to come work with you or pull them away, that's in a general sense that's usually okay. There are, it would depend on the situation specifically, but really it's kind of tailored towards the people that you worked with or that are involved in the work that you're doing. So for example, if I work in the accounting department and I'm talking to somebody that's maybe in an operational position, that may not be covered by the non-compete agreement because it's not really related to what you were doing or taking them away from there. So it definitely depends. And I think that's kind of the general answer, but like in terms of just communicating with them, there's usually not a problem there.
Okay, thank you.
I want to, someone asked.
Yeah, I have a question. I'm sorry if I need to you repeat the topic you already said. I want to restate what you talk about in this presentation. You talk about the 4 points. One is non-compete. Second is unenforceable compete or non-compete. The third one is non-disclosure agreement. The last one I didn't remember. So the first one you mentioned non-compete, which means that employee, basically means that employer, like me, I cannot work against the employee cannot against the employer, compete with the employer.
Correct.
So I didn't understand the second one, unenforceable something like that. I didn't get that. I kind of lost for that kind. So also I want to figure out what's the difference between non-compete and a non-disclosure agreement. They all look like the same to me. Thank you.
Yeah. So the second question, I can answer that part. I think that's the easy one. So they're definitely different. They can look similar. They're going to get tied together a lot, but the non-disclosure is basically you're not supposed to talk about confidential information outside of or use trade secrets or share personal information, whatever is contained within the agreement, they'll list out what they define confidential information is. You're not supposed to share that, honestly, generally with anybody, but also they can list in the agreement who you specifically cannot share that with. So it doesn't necessarily have to even be, I'm sharing that with a competitor. It could just be, I'm sharing that information, period.
Oh, okay. So
Like,
more
so-
strictly to any information, I even cannot talk. Okay.
Yeah, and it depends. Like I said, it depends on the agreement that you sign. There's a lot of different ones, but that's kind of the gist of that. When it comes to the non-compete, that's really, like you said, your competition with the employer. So working for another employer or opening a competing business that is in the exact same industry and is using the same customers as the employer that you worked for.
Okay. So what is the second part by the non-compete? Unenforceable something, or you have another one to each one of those behind of the non-compete and DNA non-disclosure. So what are those to talk about?
So when we said unenforceable, we were just kind of talking more about like whether or not the court is going to enforce the agreement on the two parties. So you can have an unenforceable version of almost any contract. And that what that would mean is that if the non-compete is unenforceable, and you breached the agreement, if you went in front of a court, they're going to determine, if they determine that it's unenforceable, that means that that agreement's not valid and that that you couldn't have been restricted, and that there aren't consequences for breaching the agreement because it was a, for lack of a better way of saying it, was a bad agreement to begin with. And not bad in the sense that it's unfair, but bad in the sense that it doesn't meet the rules that are laid out to create one that is a valid enforceable contract.
Same thing apply to the last one, the first one you talk about.
Correct.
Thank you so much.
I had a question come in from the chat. Question is, what if the contract includes that you have to pay for any legal costs, win or lose in court? Is that enforceable? So the typical rule in the US is that each side pays for their own attorney's fees. There are situations where a court may order one side to pay the other side's fees. That's typically if the one side did something kind of very bad and was something in very bad faith, or there was a willfulness of being bad against the other side, basically. If you try to put that into the contract, that could be something that the court says is unenforceable because of that general rule. But there are situations. Professor, it looks like you were about to jump in.
Yeah, so you can contractually agree in certain circumstances to have the other party pay legal fees. So I would pay close attention to that in the contract, and that's something that could be enforceable against you.
So even if even if they lose, they could still enforce you paying their costs as well?
Yeah, so if you contractually agree to it, a lot of times courts will enforce the four corners of the agreement, Texas courts in particular. So if you agree to it and you put your signature on it, then subject to some of the enforceability considerations that we've talked about, a lot of times you'll be held to that. So if you see something like that in a contract, I wouldn't just dismiss it and think it's not necessarily going to be enforceable against you. It's something that you should take into consideration when deciding whether or not to sign.
Thank you.
Yeah, I have a question. Let's say hypothetically, I did a co-op or internship before, and I signed an agreement to start, and then the week after they tell me that I have to do a 12-month program when they told me it was just 4 months. Should that have been in writing at the very beginning, or how would that work?
Of course, you can't answer specific legal.
Yeah, I know, but I was just curious.
But generally, what you agree to is what you agree to, and if maybe there was an oral So, typically look to see what you signed or that's the best way to see what you agreed to is whatever is signed. There are certain situations where you can orally modify an agreement, which then could potentially just be a new agreement. But that gets harder to prove as to what the agreement actually is, right? Sometimes that can become he said, she said situation. So typically it's best to look at what was signed, but also understand that sometimes agreements can be modified by what you say.
What if they would have said it on an email? Maybe not on the contract that you signed, but on an email would, I guess on that case, would the initial agreement have more enforcement than what they change it to later?
Yeah, that's another, it depends. Mike, you seem like you want to take that one?
Yeah, well, I was about to say the same thing, that it basically, it can depend. You can have clauses in a contract that basically state that the only way it can be changed is through like a signed, like signed written version or something along those lines. The original contract, if it doesn't have anything like that, maybe it can be orally or modified by email. So the email is definitely something to take into consideration. Whether or not it would be, an actual amendment or change would depend on what is in the first agreement in the first place when it comes to how it treats changes.
Yeah, I
So
have another
definitely keep the
question.
email.
Definitely,
Sorry, so definitely keep the email.
it's always good to keep any written communication between you and your employer.
Just
Thank you.
bolstering what Mike and Nate said, it definitely is possible to enter into a binding agreement through email. The court might look at some of those initial factors that Nate and Mike talked about at the beginning to determine whether or not that email exchange constituted a contract.
Thank you.
Yeah, I have another question. Because of COVID, are agreements able to change out of nowhere, or they're stated still? Because let's say hypothetically, I did a co-op with a company and they just cut it short because of COVID, but they just told you verbally, and they were like, but they should have it in writing, I assume. And let's say hypothetically, they want you to finish those 3 projects that you're currently doing in 2 weeks when it's supposed to take you 4 months. I don't know. It's just a question.
So some contracts have what's called the force majeure section in the contract that says, basically, if something crazy happens, if there's some unintended consequence from something happening, and a lot of them are, acts of God, that can be a way to either get out of the contract or modify the contract in a way that makes sense for the circumstances that came up. So I know a lot of companies are dealing with that now as to how COVID relates to their force majeure section of their contract. There's different, because those sound like a very standard language. They might have explicitly in there a pandemic, or might just say something more general. So whether or not COVID applies to those is kind of depends on the contract and is still somewhat up in the air. So that answer the question generally.
I have a question. My question is not related to non-disclosure agreements or non-compete agreements, but it does have to do with vaccines. Is it lawful for an employer to enforce an employee to get vaccinated, for example, with the COVID-19 vaccine, in order to receive employment?
So it depends obviously on the state. If it's an at-will state, they can fire you or hire you for whatever reason. But that then depends on, there are situations where the state might make a law that says you can't hire or fire someone for a certain reason. I'm not saying that COVID has had any laws like that, but something to look at.
I'm sorry, could you repeat that at the end? You kind of cut off a little.
I'm not sure whether or not Texas has had that law, is to say you can't hire or fire someone for having or not having the COVID-19 vaccine. That would be a situation if they did have that law that, then they couldn't hire or fire you for that reason. But generally, in Texas, you can be hired or fired for no reason. But it depends on the state.
Yeah, again, that's kind of outside the scope of what we prepared for. But generally speaking, if there's a health and safety basis for it, then the employer is going to have pretty broad discretion. I had heard of some instances of employers requiring their employees to be vaccinated, right, or terminate employment. So I think some employers are doing that.
Okay, thank you very much.
I have a question about the non-compete. For example, if you're in an interview, if you don't compete with another company, I'm sure it's in the best interest that you do disclose it to them. But let's just say you did not. There wouldn't be any repercussions for that company that hired you, right? So anything you did on your part, the former company will go after you, the employee, the ex-employee versus the company, right?
So you cut out a little bit. I think what you're asking is like, so if you had an internship, or not an internship, but you had an interview with another company, you don't disclose that you have a non-compete agreement with your previous employer. The employer, when they find out, they're going after you yourself as an individual, not the company that you're going to work for.
Yes.
And I believe that's generally correct. There may be certain instances in which that could be a problem. Nate, you can chime in, but I think on the whole, the agreement is with you and you've breached it.
Yeah, there are, and this speaks more to NDAs than non-competes, but if, say, the company knew that their employee, they brought on this employee because they worked for a previous company, they knew they had some confidential information, and they tried to get that from that employee, then that new employer could be on the hook for some of those damages or some of those lost profits because of they purposely took on that employee just to get that confidential information. But as far as
Okay, I asked because there was instances where there's a lot of layoffs in the recent past, and our corporation was trying to hire people. And one of the questions they were asking were, do you have a non-compete? And they would say yes, and we wouldn't look at them anymore. We wouldn't pursue them any further. Because there's candidates out there that don't have non-compete. So I'm just curious. Thank you.
Yeah, and sometimes even with it might just be in their best interest to avoid it, just so that there's not the potential for a situation, and that's why they would kind of disregard the employees with a non-compete, because even in lawsuits that aren't valid are necessarily expensive too. So I think there's a variety of reasons why they would want to go that direction.
Yeah, I don't, in the instance you mentioned, I don't think there's going to be a contractual claim, right? Because the new employer didn't sign anything. But like Nate said, there might be some other cause of action not based on contract that could cause some liability.
So we just got a question in the chat. Says, for non-competes and NDAs, how is jurisdiction, i.e. Texas statutes and venue, determined? Is it the employee's state of domicile, the organization's state of incorporation, or are there other determinants at play? So I think the easiest way for this to be determined is to look at the agreement. Typically, the agreement is going to say what law governs. If that's not there, or if the employee is in one state, the company is in another state, there are different rules, and that becomes much more complicated. But typically, you look at what the agreement says, and that's where you have to get sued.
So I have a question with the non-compete. What if an employer started a competing company and the previous employer never pursued it until, let's say, a few years later? Would that count? Like if they said, oh, maybe it's been past what we said now, but before they were popular, they kind of had this agreement with us so that they didn't keep up with their contract from before that time. So it doesn't matter if this was a while ago and now they're popular. Now we're going to go after them because they are popular and they did not keep up with the agreement, something like that.
Yeah, so I think the term of the agreement comes into play there. So like if you're looking at the term and it's 2 years and they decide to come after you 3 or 4 years later, you know, obviously I think then it might change things a little bit. I'm not 100% certain on, I guess, any limitations beyond that.
I guess it'd be statute of limitations for those claims. Generally, you have to look to see what those are. But also, the company could potentially, if you started that company in that period where you said you wouldn't compete, you know, you breached the contract then. But then that's when the statute of limitations might start. And how long after that the company brought an action against you or, you know, sued you, that depends on what the statute of limitations might be.
Okay, thank you.
Well, I have a question.
Can I
So
ask a brief question?
No, go ahead.
I want to know, as a student, I never saw a labor contract before. So when I have a contract or anything, which parts, which clauses, all of those will be in that contract I need to pay attention to? If you can give me some suggestion.
So I think every agreement you see will end up being different, and they can format them in a bunch of different ways. So it kind of makes it a little difficult to say specifically. A lot of contracts have headings. And so if you're looking specifically for non-compete portions or non-disclosure portions, then, you know, the variety of terms that we gave you earlier, how a non-compete could be called a covenant not to compete, or how a non-disclosure agreement could also be a confidentiality agreement. You can look for headings that kind of call those out. Usually they're going to be kind of, I know from my company's perspective, it was, you know, we things like that are lumped in like an employment agreement packet that would be given to you. And usually the HR departments at most companies will walk you through that. But in terms of like where you're looking for, really, I think the general advice I would have is you're going to have to kind of look for them. I know it's because they can format them in a bunch of different ways, where it might be at the beginning, it might be at the end, it might be somewhere in the middle. So you can look for those headings to kind of clear that up a little bit.
Okay, thank you.
Is the recording going to be available?
Yes, the recording will be available on
Yep.
probably on the University Career Services YouTube channel.
Yeah, I have another
Thank you.
question. So for the non-disclosure agreement, how are all those electronic car companies that are competing against Tesla able to compete? Because most of them are ex-Tesla employees. How are they able to do the competition? I don't know.
So I guess generally speaking, I can probably guarantee you that Tesla is suing people. And so that does definitely happen. Like it depends on the agreement specifically for each one of those. I mean, they depends on the state. There's certain limitations that, you know, we might be able to do in Texas that they can't do in California, where, you know, Tesla's based in California, right? And that can come into play. Sometimes it might not be worth their while to go after them.
And I don't know California law, but just from what I've heard, California's non-compete agreements are even less enforceable. They're like one of the least enforceable states. As far as, I don't know that for sure, but that's just what I've heard.
For like Tesla and with Elon Musk, what I've heard is that they have some of their stuff up in public so that other companies can grow on that and make it happen, you know, in the case that he's not able to. I'm guessing that has something to do with it.
It very well may. I remember I think Tesla has a very public like patent bank or something along those lines where they're very big on sharing their intellectual property, which there's a variety of business reasons they do that. It's not all altruistic, but that may very well apply to some of the employees as well. That's a good point.
Awesome. Thank you.
There any other questions?
No,
Right.
thank you very much. I was a little late, but everything else was very helpful.
Yes, yes. One last one to wrap it up. So the company can make their own non-compete or non-closure contract. But if it's work or not, it's need to bring up to the court to let the judge to say if it's okay or if it's not okay, right? Okay, this makes the labor market, the people like me, I need to know more about I don't know the standard, if it's okay or if it's not okay.
Well, you can definitely refer back to the presentation to kind of give you an idea of what Texas's standard is. So that'll let
Okay,
you
okay,
have an
I will
idea.
keep that one. Yeah,
Yep.
finally I got it. Thank you.
Okay, well, it looks like this will conclude our presentation. Thank you everyone for being here. Thank you to all of our presenters. Great questions, great information.
Yes, it was. Bye.
Bye-bye. Thank you.
Thanks, everyone.
Thanks, everyone.
Bye-bye. Thank you very much.
Thanks, Cynthia. Thanks for organizing this. It was
Sure.
excellent.